Go-ahead signal. All right, just to begin, today this is our third time doing a conference, and we are lucky enough to have Marilee Orsini, who is a very active member of the National Private Duty Association, be with us tonight to be our moderator and kind of help get things going and introduce the speakers and answer some questions at the end, hopefully. Anyway, she is a seasoned geriatric care manager with over 30 years of experience. She has 18 in direct service provision and 13 in marketing. She is active on the national level as a speaker, consultant, and a strategist, and is the founder of the company called CoreCube.com. I'd like to welcome Marilee. Are you there, Marilee?
I am, Joni. Thank you so much.
Take it away.
Well, I'd like to thank everyone again, as Joni said, for attending tonight. This session really is about the tax and legal risks that occur when you do hire a caregiver. And you know, hiring someone to help when you do have a senior or a loved one or someone who is having some issues taking care of themselves, hiring someone to come in and help might seem like a simple thing, but there are lots and lots of choices. And we have two experts with us tonight to cover those choices, because there are really a variety of ways you can go. The National Private Duty Association is a trade association for agencies who employ their caregivers, and that, of course, is the safest way to go if you are going to hire a caregiver. But a lot of people try it other ways, and so there are different models of even agencies. Some agencies actually don't employ their caregivers. You might get a referral from a friend, or you might find someone in a newspaper or on Craigslist, or someone might be referred to you. So there really are a lot of potential risks and liabilities, and we feel that you really need to have full knowledge of what you're going into when this does happen. So the main question that you'll need to ask is, who employs the caregiver? That's sort of one of the keys. Well, let me turn this over now to our experts. First, let me introduce you to William Murphy. He is a CPA, and basically he specializes in taxation, auditing, and small business development, and he's worked with local and national CPA firms. And he is now with Mailer Grodner, and prior to that he owned William F. Murphy and Company, and he is the former director with the Indiana Attorney General's Office. He did receive his BA from Butler University in Indianapolis. And our second presenter is John Gilliland II. And John Gilliland is really someone who's very, very well known in this industry and has represented virtually all types of healthcare providers. He's a frequent speaker, and he's an author concerning labor, employment, and health law issues, and his primary areas of practice are labor, employment law, and health law. He is with the Indianapolis law firm of Gilliland and Marquette, and he has a BA from Pennsylvania State University, and also his JD from Georgetown University Law Center in Washington, D.C. So, Bill Murphy, would you like to start us off tonight? Whoops, let me first tell you just a brief overview of today's topics. Bill Murphy will cover the tax risks, the employee versus independent contractor issues, IRS worker classification, and tax rules and responsibilities, and then we'll switch over to John Gilliland, who will talk about legal risks and the two types of legal risks, and if someone is an independent contractor and if someone is not an independent contractor. So, Bill Murphy, would you like to start our webinar tonight?
Thank you very much. Thanks for having me. This area that we're going to talk about tonight is an area that continues to be and receive a high degree of audit sensitivity from the Internal Revenue Service, simply because it's not very well understood, and many individuals try to essentially employ individuals to do certain tasks, and in this case a caregiver in your home, and they don't realize how difficult or what the challenges might be in trying to not only take care of the compliance side of it, in other words, the filing of the proper returns and the proper acknowledging of what needs to be sent to the individual, but also understanding what they will be getting themselves into on a tax basis if they're not careful. The current IRS focus right now that we see in this whole area of employee versus independent contractor areas stems from a original revenue ruling that came out in 1987 called 8741. And at that point in time, the service promulgated certain rules that would define under these 20 tests as to who an individual and how an individual would be classified as either an employee or an independent contractor. Now, these 20 tests have been now updated and changed to some degree into a more well-defined rule base, which focus on areas of behavior, in other words, behavioral control, financial control, and then we have these relationship controls. Now, to be very simplistic, when you look at this whole area of defining whether a person qualifies as your employee or an independent contractor, one must really kind of look at the heart of what the law says and what the service is looking at from the standpoint of whether that individual comes under your care and control in the daily function of those duties, or whether you're just basically looking at the end result. Now, there's a form called SS8 that has been suggested and is highly used by the Internal Revenue Service when they're trying to determine the classification of workers. Now, just a warning at the very beginning that if, in fact, the Internal Revenue Service finds an individual that they are auditing, they are now required by the Internal Revenue Service handbook to look at every tax return that is being filed by that individual or that company to determine whether there are any disguised workers. So when you get down into the behavioral control, what you're really saying is when you determine, trying to figure out which side of the fence you're going to go on, if in fact that worker, that person that you have control over, do they take instructions from you? What kind of training do they receive? Are they retraining from you or from independent areas? Those kinds of things. Financial controls are a little bit easier to define. When you look at from financial controls, do certain controls exist? You're looking at things like whether the worker can realize a profit and whether there's investment risk and those kinds of things. What does the worker set their own hours? Are they open to the public? And so on and so forth. But when you get to the heart of the issue, and that's relationships, you're really looking at things that John will talk about in a second, whether there's actually a contractual relationship involved. Does the business provide a worker any benefits such as a pension plan or vacation, or whether this is permanent or temporary. Now, when you look at the overall topic of whether a person that you employ is going to be deemed as an employee versus an independent contractor, obviously the Internal Revenue Service would say most likely if you have significant control over those persons' actions, duties, they work under your control in your home in this case, they probably will be determined as probably an employee. But many times individuals try to take the easy way out, and they look at the standpoint of classifying these individuals as, quote, an independent contractor. In other words, we pay them so much money, they come in and they provide care and services in our home. We give them a check and hopefully a 1099 at the end of the year for services rendered, and they there's no payroll obligation, reporting obligations, those kinds of things. But the point of this is that the Internal Revenue Service, if they find an individual that has not been paying payroll taxes, either as an employer or an individual that receives a 1099 and does not pay the tax on those services through their individual tax filing, the service will go back to the original source and look at that individual and qualify that individual under these three tests, under the behavioral control, financial control, and the relationship that exists between the parties to determine whether that individual should have been classified as an employee from the very beginning, and if they fail the test and you have not provided them and not deemed them to be an employee when the service deems them to be an employee, then you risk penalties, interest, and a lot of really difficult times. And that's where I usually get in, is when an individual has been approached under an audit situation and they're trying to alleviate the problem of this ongoing audit and where do we go from here, that type of thing. And that's what we're primarily involved in. So when you look at the idea of an employee versus an independent contractor, You also have to look at what are the required forms, what are your responsibilities as a payee, and what are the risks that you're going to sustain if, in fact, you don't live up to your responsibilities. Form-wise, it's very time-consuming because you're going to have quarterly forms, 941s, you're going to have state forms, and you're going to do a withholding of wages based on the IRS tables, payroll tax tables, and file those deposits in a timely fashion. Now, if this is something that you are not familiar with, not comfortable with, you may have to sustain additional costs to turn those over to another provider, a Paychex, an ADP, or somebody like that. But you have significant responsibilities if you determine the individual as an employee. You also have responsibilities even if you're not deeming them as an employee. If you feel that you can skate around the employee situation, that you look at this from the standpoint of what you're required to file. Now, absolutely, an individual is required to file a Form 1099 with that individual on a yearly basis, noting if the individual that received more than $600 during that period of time. And then at that, with that requirement, you would file the appropriate filing with the Internal Revenue Service showing that that was paid. Now, the reason that the 1099 is so important is because of a safe harbor that the Internal Revenue, or that Congress put together and has determined as a relief from classification of being an employee, and that's under Code Section 530. And what that really looks to is the fact is, does the individual under the safe harbor perhaps qualify to escape being classified as an employee? The Internal Revenue Service manual goes into great detail as to how that individual might qualify. There's a publication called 1976 that's out there for your view, and also the irs.gov website has a lot of information about that. But the reason this is so important is because the courts have determined that if, in fact, at least that filing of 1099 and the intent, you might qualify under Code Section 530, and you might have some reasonable basis to set forth in this subjective test to qualify. But I can't underestimate what the responsibilities, the time, and also the risks that you're going to incur if, in fact, you classify an individual perhaps as a subcontractor versus an employee. That's the whole purpose here when we look at what the attractiveness is of using a private duty agency, whereby you essentially have all these problems and filing requirements taken care of. But you just have to be very careful. The whole idea of classification and also whether this individual that you have in your home is going to pay their taxes. And quite frankly, some of the cases that I run into are originating by the individual not filing or paying tax on those monies that they received from providing care services in the home, and this has then generated an audit on them as well as through collection, as well as an audit on the individual that paid. But be aware that the service is looking at this. They're defining very rigidly whether the individual is going to be classified as an employee versus a subcontractor. And once they make that determination, you have appeal rights, obviously. But the problems that occur and the costs incurred of trying to sustain a justification as a subcontractor versus an employee are significant and should not be understated. And from that aspect, I think we just have to, if you have individuals that you are hiring and paying, you have a record reporting requirement. You keep good records, when they were paid, how they were paid. You have withholding. The withholding has to be paid timely. And you have to make the obviously appropriate filings at quarterly as well as year-end, including preparing the W-2s for the individuals. So if you have someone in your home that falls into this area, I think you really need to step back, find professionals if that's what you're going to do, and make sure that you're covered. That's why the attractiveness of using a caregiver from a private duty agency is so attractive, in that all these risks, these problems that have occurred or could occur, are taken out of your hands. You have a kind of a one-stop shop. They take over that responsibility, and you don't have to worry about whether this individual is an employee or an independent contractor. And I think that kind of covers, in my part, some of the rules and regulations that you need to be aware of, and understand that it's a very dangerous world out there, especially when it comes to individuals that you have hired and are paying them over $600.
Thank you so much, Bill Murphy. That was really wonderful. And again, what he is talking about are not hiring through an agency, but hiring someone independently, or hiring from an agency that doesn't employ their caregivers. So,
correct.
And next we'll have John Gilliland, who will continue to talk about the independent contractor and not independent contractor. John?
Thank you, Mary Lee. Those of you that are listening, think of it this way. Anyone that you hire as a caregiver, where you contract with the individual directly, is either an independent contractor or an employee. They must be one or the other. And there's risks, whichever one they are. We're going to come to those risks in a moment, but I want to mention something initially, because the first legal risk is whether or not you've properly classified them as an independent contractor or an employee. Bill just covered the test that's used by IRS. That is known as the common law test, basically. But what's important to remember is that there are different tests depending on the purpose for which you're determining the person's status. It is entirely possible that someone would not be an employee for IRS purposes, but be an employee for purposes of overtime or unemployment compensation. And if you improperly classify them as an independent contractor, it means you're not complying with all those employment laws that are there to protect them as employees. You also need to remember that what you call them almost doesn't matter at all. The courts, the various enforcement agencies will look at the actual factual situation to determine their status, not what you call them, not what a written contract calls them. So you need to remember it's not just an IRS issue. Proper classification depends on the purpose for which it's being determined. Now, once you've got them properly classified, the risks depend on whether they are in fact an independent contractor or they aren't an independent contractor, meaning they're an employee. Let's take the first one first. If they are an independent contractor, you still have various risks involved. What if they're injured on your premises? Do you have insurance coverage to cover that? Now, if they were your employee, you probably have to have workers' compensation coverage. We're taking here they are an independent contractor, so you don't have that. Lack of supervision. By the very nature of being an independent contractor, you're not supervising them. No one else is supervising them. Who's paying attention to quality? Who's looking over their shoulder? Just in general, what is their performance? You cannot control the manner and means by which they perform their work if they're an independent contractor. Scheduling concerns. They don't show up for work. They're always late. They call in sick, letting you know they're sick. Who finds their replacement? With an independent contractor, you can't do that for them in most cases. So that dealing with an individual independent contractor, you begin to experience those practical difficulties dealing with scheduling. You may say, well, I can take care of that. I'll work with them on the scheduling and everything. But wait, if they're an independent contractor, you can't get into that detail with them. You cannot control the manner and means by which they perform the work. Training. Have they gotten any training? Are they appropriately trained for the work they're going to be providing for you? Do you provide training? If you provide the training, That's an indication that they're perhaps not an independent contractor. And finally, one last one to mention, unfortunately, is the area of abuse and exploitation. Unfortunately, that does happen. With an individual who's an independent contractor, you don't have anyone looking over their shoulder to make sure things are done safely and that everything's okay with your loved one. The point is, if they're independent contractors, there's not control. You, by the very nature of them being an independent contractor, they're not subject to your control. Now let's say they aren't an independent contractor. They're actually, that's an odd way of saying, they're your employee. Well, now you run into a different set of liability issues. As your employee, you've got the various IRS ramifications Bill mentioned, but now you have other things you have to look at. Are they entitled to minimum wage and overtime pay? That will probably depend on your state's law. How about unemployment compensation? Many states have a definition in their unemployment compensation statute defining the criteria that must be met before someone is an independent contractor. Rarely does an individual that you would hire meet that definition. They have to be in business for themselves. They have to really be, I like to think, and I find them in the yellow pages. People that are in business for themselves want to be found. Unfortunately, independent or individual caregivers often don't have that. So you have to be sure that you're okay with unemployment comp. Now, they may be an employee for unemployment comp, but there may be an exception in the statute that relieves you of making unemployment compensation contributions. It's going to depend on state law. Workers' compensation is very much the same. If they're an employee, you've got to look at the issues of, do you have to carry workers' compensation coverage for them? That will depend on your state's law. And you just have the overall risks of being an employer. You have to comply with all the various employment laws. And do you know what they are, or who you can consult with to find out everything you need to comply with? Remember, it's not just an IRS issue. If they're your employee, just to give you a feel, do you have to comply with occupational safety and health requirements? I know of one state that every employer, doesn't matter how many employees they have, must have policies on universal precautions, which is a safety measure to protect them from bloodborne pathogens. Do you even know how to put those policies together? Do you get a Form I-9? I suspect that many of you haven't heard of that. That is a form that every employer must obtain to prove that the person is in the country legally and entitled to employment. It applies even if you just have one employee. If you just have one employee, you also have to comply with the federal law dealing with military absences and all the discrimination laws in that regard. The point is, first step is, have you properly characterized them as an independent contractor or employee, and that can be different for different purposes. IRS is not the only purpose, and it doesn't control for other purposes. If they're then an independent contractor, you have various issues relating back primarily to kinds of supervision or the lack of supervision. And if they in fact are an employee, you have all the issues of being an employer and being sure you comply with the various employment laws, most of which carry fairly substantial penalties if you don't comply with them. So, Marilee, that's a quick overview of that issue for you.
Okay. Are you going to talk about, I guess you have talked about the advantages of using caregivers. I don't think you have the advantages of using caregivers from private duty agencies.
Well, the advantage there would be simply you avoid all these issues, because when you're obtaining the caregiver through a private duty agency where that agency they're employed by that agency, everybody knows they're an employee of that agency is taking care of all these issues as the employer. And on a very practical matter, If the caregiver can't arrive for work when you were expecting them, the agency finds a replacement and sends the replacement and works with you on that. You basically don't have all the problems and issues you encounter by hiring the person directly.
Very good. I think we have several questions here, but I wanted to go over one thing because some of these questions really do relate to. One of the questions had to do with hiring a caregiver from an established agency. And I would like you to just briefly talk about, because there are established agencies that actually don't employ their caregivers but are simply matching caregiver with client. And that is sometimes called a nurse's registry. Would you just cover that quickly?
Sure, I'd be very glad to. Yes, they're typically referred to as registries, and they treat the caregivers as being independent contractors. They're saying they're not our employees, we're just simply matching them with you, the family, or the client. The difficulty in that regard is, are they really indeed independent contractors of that agency? And even if they are, they very well may be the client or family's employee. There is one provision in the Internal Revenue Code that allows an agency like that, a registry, to avoid having to withhold employment taxes and things like that. But the regulations emphasize, hey, they may in fact be an employee of the family that they're matched to, or the client. The difficulty with the registry approach is you get back to the situation of the lack of supervision, all those risks that I listed or mentioned under if they are an independent contractor, but you also have the risk that in fact they're your employee anyway. Now, there are some states in which registries can function and be okay under various state laws, but just taking one example, none of those state laws affect their status for purposes of minimum wage and overtime pay, or for the military discrimination statute or the Form I-9, those kinds of things. So you still have problems as the family or client.
I'm going to briefly mention these resources. Thank you, John, for explaining that better. The two resources here, the National Private Duty Association, which you can find at www.privatedutyhomecare.org, does have a lot of resources that go into this more deeply. The Independent Contractor versus Employee paper, a position paper on consumer risks, and if you look under quick links, you can find those. And we've also listed here the publication 15A at the IRS website, and I'm not going to read that off to you, but if you go to irs.gov, you can look, and it's under publications, you can look for this publication 15A. And I have a question here that says, can we simply, and this is probably for you, Bill, can we simply contact the IRS and have them tell us if a person is an independent contractor?
That's a good question, Marilee. If you were to call the Internal Revenue Service, they would probably direct you back, and they have the form on their website, dealing with Form SS-8, determination of worker status for purpose of federal employment taxes and income withholding. They would ask you to fill this out. Then it's submitted to the Internal Revenue Service for their review. There's no cost involved in this, but it's very detailed and signed under penalties of perjury, that you declare that you've examined and that you've got this request in place. So they'll come back and determine if that person qualifies and as an employee or not. It goes through the same things that we've talked about tonight, with just general information, behavioral control, financial control, and relationships. Generally speaking, it's been my experience, is most of the time, more than 95% of the time, the service will probably declare that individual an employee, which then would, as John properly said, would put you in the tract where you would have the reporting requirements and all the additional responsibilities to file properly, file timely, withhold taxes, and do this in an orderly fashion. And this is not an easy function, even for pros in the business. So that's how the Internal Revenue Service would approach determining whether a person would qualify or not. And they would many times after this is filed, come back to the individual, ask for additional information. But once you file it, and once you've agreed that this is something that you're asking for a decision, although there's no fee involved, it is binding. And great care must be taken with both the answers that are given as well as the determination of the relationship that is being requested.
Mary Lee, can I add something to that?
Sure, please.
And this is really something I mentioned in my portion of it, and I just want to emphasize it. Everything Bill said is absolutely correct, but remember, that's the IRS determination.
Absolutely.
Even if IRS said the person was an independent contractor, that doesn't mean they're an independent contractor for unemployment comp, workers' comp, minimum wage, and overtime, all those things. And the only reason I mention it is because it's so common for you to just think IRS, and part of my big message from the legal perspective is that's IRS. You've still got to look to all the other purposes.
Absolutely correct.
Yeah.
Now, John, you answered this when you presented, but this question has come in again, and I think we need to reinforce it. Can I just avoid all of the problems that you're talking about with a good contract?
No. Contract cannot make someone an independent contractor. What is important are the actual facts. And if you're treating someone as an independent contractor simply and only because you have a contract that calls them one, the odds are they aren't an independent contractor. They're really an employee. A contract can be very helpful in confirming the actual factual situation, but it can't change the facts. Don't rely on just a contract.
Okay, several more questions are coming in, and some of these are detailed. Let me take a more general one. How do you determine if it's a registry or an agency?
You would look at does the registry or agency say that they're sending you their employee? If they're sending you their employee, they're an agency. The agency is the employer. If it's a registry, they will say, no, it's not our employee. We're just a matchmaker. The person is an independent contractor. They may not say they're an independent contractor because it's entirely possible that the person isn't their employee but is your employee. So the biggest key is, what does the agency or registry say? An agency will say the caregiver is our employee. We worry about all that. A registry will say, no, they're not our employee.
Well, thank you. Very good. We are getting some very interesting questions here. Is a son or a daughter that takes care of a parent classified as an employee or an independent contractor?
Would you like to try that one, Bill,
I would.
for IRS?
It's interesting that was brought up, because there is on the IRS website a Q&A on frequently asked questions. That very question. And it comes down to what John has been emphasizing from the very beginning. You have to look at the facts and circumstances. Generally speaking, when you employ an individual and you actually fall on the side, let's say, for example, that they are and quote an independent contractor, and you at least you attempt to do that. The service, I think, has been my experience, has generally gone back after they do the tests and they ask the questions, that it's almost impossible for that individual to qualify as an independent contractor as much as you might like to. So they are really driving in that direction, that person, even though they're related, even though they're living in that under that household, it goes back for and I'm just talking about IRS purposes. It goes back facts and circumstances. What are the relationships? How is that person paid? And when you look at getting back to this SS8 for IRS purposes, what are the behavioral controls, the financial controls, and then the relationship? And in Part 4 of the SS8, when they talk about relationships, there's a question that talks about how that individual is related, whether they are related or not. So I think great care has to be given, because that the service, I can't say this enough, the service is looking. And this is one of the highest audit areas in the area of payroll right now.
Now, here's a question that I don't know you're going to know the answer to, but I'm going to read it anyway. It appears that many caregivers are working in registries in order to avoid paying taxes. Is the registry required to file a 1099 on the caregiver's behalf?
Bill, since it was tax, why don't you take it?
Yeah, it doesn't matter whether it be a registry or anything else. If an individual pays another individual for services rendered in excess of $600, they are required to file a Form 1099, period. So if and this is the situation that comes up many times under audits, is that everyone thinks that somebody else had that responsibility. But if you are paying for that individual, I still think that you have a filing requirement. And I always err on the side of being very conservative and filing so that you at least have the attempt so that you can opt out of the penalties that are associated with the non-filing and the non-reporting. Because once that is passed, we have two very big cases that came out of the Court of Appeals in the last 16 months that both of those hinged on the fact that 1099s were not provided, which forced the employer, or the payor, I should say, significant damages and penalties. So always do a 1099, and if you have any doubt that one was not issued, then I think you have the responsibility to do it. What do you think? What do you think, John?
I agree, and one thing that's not uncommon with registries is that you don't pay the registry, you pay the caregiver directly, and then pay a different amount to the registry for their services in doing the matchmaking. So you do have to look at that situation. If it was being done that way, it seems pretty clearly the family client has to do the 1099.
Yes.
Do you agree, Bill?
I agree, and almost to a T, when you look at only having one 1099 filed, or say, for example, it's $3,000, $4,000, $5,000, and there is any question, the service, as a routine, will send out a letter to the individual that prepared the 1099, the family, and send them along a Form SS8 and ask you to fill it out, so that they then are asking you to essentially tell them what the facts and circumstances were of that employment issue, so that they can make the determination. And if you don't fill it out, then they either give you a call or a knock on the door. It's very they are putting their resources into this area because of the payroll tax issues and the tax issues.
Here's a question, John. It says, you addressed the unemployment compensation situation as one different from the IRS issues. And how does this person find out about workers' comp in their state?
Well,
unemployment compensation.
Workers' comp and unemployment comp.
Unemployment insurance and workers' comp.
They're both state law issues, and you'd have to consult the statutes in your state. States are very different on unemployment comp and workers' comp, and what definitions are used for an independent contractor versus an employee. You really have to look to your state statutes. With the Internet, in every state now, you can usually easily get to the statutes of your state. Just go to your state's website. Usually under the legislature, it leads you down to a copy of the statutes. Go to the unemployment comp statute, workers' comp statute, and see what the definitions are. If you have any doubt at all, you should consult an attorney, because it's not unusual for the non-attorney to read those definitions and perhaps not quite get the significance of them. But you consult state law, basically.
We've got two very specific questions about IRS Publication 15A, and they read to me as if they are from someone who is who's trying to give advice on that or something. So I'm going to, for that person, I'll tell you I'm going to ask Bill to respond to you privately after this, because I don't think it's in the general interest. Sure. And there's another one that has to do with a business from Great Britain, from the United Kingdom, who is seeking to establish a business here in the United States. So, John, this may be a new client for you. Can you speak to the relevance of this topic relating to this particular situation for a UK-based organization to come and provide caregiving services in America?
But probably the biggest thing to remember there is that as you come in, what the situation is going to be dependent on the state that you establish your office in. And then when you establish your next office in another state, you've got to review everything again. In essence, America is 50 separate countries. And I think that would be the biggest thing, where in Great Britain you'd have a uniformity of the law fairly much. In the United States, if you go into New York, there's one set of laws. If you then expand into New Jersey, it's a different set of laws that can be quite different from state to state. I think that would be the big thing. And you need to determine, probably if you're coming over, you're coming into one state initially, and it's important to know the law of that state as it applies to the kind of business you're opening.
Now, I have an excellent question. This is really, really good and very important. If you're using an agency, is the liability insurance carried on your homeowner's policy sufficient to cover the caregiver for workers' compensation? And then I'm going to expand that and say, if you're hiring someone who doesn't work for an agency, cover that also. And this will be our last question, I think.
Okay. For the caregiver that is employed by an agency, workers' compensation is provided by the agency. And you as the homeowner wouldn't have the direct workers' compensation consequences there. If they're not employed by an agency, or even when they are and you're wanting to be sure that you have insurance coverage, my comment is any dang fool can file a lawsuit. So you may be perfectly in the right, but you've got to defend a lawsuit. And it's often overlooked that your insurance carrier will provide the attorneys and things to do that, which is worth a lot of money to you. What I would suggest is, because insurance policies do differ, you discuss it with your agent to explain that you're having a caregiver coming in and you're wanting to be sure, if there was an injury or something like that, that you do have insurance coverage under your homeowners or otherwise that will step up for the defense.
Very good. Well, I want to just thank you so much, Bill Murphy and John Gilliland, and thank you, audience, for attending. This is another wonderful educational resource about caregiving provided by the National Private Duty Association. And please visit the website. Here it is, privatedutyhomecare.org, if you have any questions or need any resources, or if you'd like to find an agency to provide some care for your loved one and avoid all of these issues that both Bill and John have talked about tonight. So this was recorded. Anyone who attended or registered will get a copy of this. So again, we thank you very much, and we hope everyone has a great evening tonight. Thank you.
Thanks very much for having us.
Thank you.
Bye.